Hi, my name is Roger Enriquez. I'm an associate professor at the University of Texas at San Antonio, and I'm also a lawyer. And for the last 4 or 5 years, I've been helping folks who come to the Mexican American Unity Council to either keep, clear title, or help them clean up title using things like transfer on death deeds, affidavits of heirship, etc. And I like to start out with something you'll find in your packet or your file for each client. And these are actual folks that we've helped, so that you can get a sense of what the documents are going to look like. What you have in front of you is a title report, and as you can see, it's prepared for MAUC, Mexican American Unity Council. And the folks who are interested in creating a TODD are a couple. You can see their names right here as well, Raquel and Roberto. Report says title appears to be in Roberto and Raquel's name, which is good. We'd like to see that. Looks like they borrowed some money back in '89. Then they went and got a equity lien, line of credit, something like that. There as well. Of course, obviously the family should be aware of things like that. And we do this just to make certain that there are no surprises here. I'm going to show you something that comes up on the next page, though. An involuntary lien. It appears that there might be, you will explore this with the client on your own. It's not necessarily going to prevent them from doing the TODD, but in some instances, you're going to find that folks are completely unaware of this. It appears that the wife may have had a credit card. Looks like the case was opened in 2011. This particular judgment or lien was filed in 2014. The comments seem to suggest that this is, in fact, the spouse, because the address and the date of birth track to the folks here. Like I said, sometimes they may not even know about this stuff, so you make them aware. Often there's absolutely nothing here, but it just so happens that this one has something there. And then lastly, on the last page is a good legal description. Okay. Now, this is the information that we'll use to create. Now, MAUC is very good about putting the documents actually together for us. So let me go here to another page, which is a questionnaire for transfer on death deed. And again, we can typically fill this out ourselves, or have sometimes the client, because they come in saying, look, I know exactly what I want, they'll begin to fill all this out for us. You'll see that obviously the name of the property owners. I should mention that with husbands and wives, as in the case of the folks that I just showed you on a previous page, what we like to do is very similar to what you would do with a will, is Roberto does a transfer on death deed to the primary, Raquel, and then the other one is just a mirror image. Raquel does one in favor of Roberto. Something should happen to her, and in this particular case, they left it to the daughter, so the daughter was the alternate. So there's actually 2 transfer on death deeds that get created here, one for each of the spouses. Okay. Now going back, and the reason I remembered that is because in the questionnaire, the way the questionnaire is structured, sort of name of property owner, primary beneficiaries, we'll need their address, we'll need the current address for also the alternate. There's a couple lines here in case they want to have 2. The second page is in Spanish for folks who are not English proficient. Okay. And so together, all these documents are the ones that sort of put all of that together for us. Okay, as promised, what you see on the screen, of course, is the revocable transfer on death deed. It's pretty straightforward. Currently, what you're seeing on your screen is a template, right? And based on the information that folks provide, the folks at Mock will feed that in, and of course, this will all be filled out. Has the date, obviously the person making this deed, the owner's address, city, state, zip code. All of this is pretty standard stuff. The thing that I like to remind folks, of course, is that this is revocable. In the event that they change their mind, they can absolutely do that. They retain all the rights that they've had before with the property, whatever those rights were. So they keep their exemptions. For example, if they want to sell the home, they can still sell the home. If they want to borrow against the home, they can borrow against the property. The only difference is that they are, in fact, naming their beneficiaries in the event that something should happen to them, should pass away. The home would go to their primary beneficiary or beneficiaries. And in the event that something should happen to their primary, then of course it would go to their alternates if they so desire to choose an alternate. The forms that we use are sort of catch-all, to try to, follow the state forms, or at least the templates, right? Part A says if at least one primary beneficiary survives me. In some instances, people choose two primary beneficiaries, so they have to decide in the event that one of the primary beneficiaries passes, what happens? So if you have two primaries, to the one that passes away, does that automatically pass to their heirs, or do we want the surviving primary beneficiary to keep the property? Right? Folks who, if the no primary beneficiary survives me, in other words, there's no primary beneficiary around, whether they listed one and they didn't survive, or they predeceased, or they listed two and they're both gone, then they have, again, the same kind of choice. And you can read the language, but the gist of it is that it's an anti-lapse election. So does it go to their heirs or to the surviving alternate beneficiary? Well, once again, same kind of deal. And Part C kind of mimics that. These are all sort of the same idea. Again, folks can have multiple alternates, multiple primaries. They'll simply place their initials by their choice. Notice that it says here, if you do not choose an option, then option 1, which is the anti-lapse, will apply. So even not initialing, basically, there's a default. Of course, they date it, they sign it, then the notary does their magic, and that's basically it. Again, if you have couples, each one does one in favor of the other, and then maybe they list a son or daughter or multiple kids, whatever the case may be. Again, it's good to explain to folks that this is revocable, so it's not necessarily set in stone. They can change their minds down the road if they desire. They'll need to obviously revoke it, put another one in place, but that's usually a pretty straightforward process for them. I know that Mock, we've done those at Mock, not very many, but folks have come back because, they, for whatever reason, had a change of heart, and we just simply revoke it and then create another one. Well, listen, I hope this has been helpful, and look forward to working with folks.